Namaskar. Hello everyone. Welcome back to the show. We have with us Mrs. Shweta Anand, founder of Kalpavruksha, an alternative dispute resolution forum. In the previous episode, she spoke briefly about ADR, its types and its mechanisms. Today, we shall continue knowing further what is ADR through her. Namaste, madam. Last time we spoke about the types of ADR, its mechanisms, and its need in India. We would like to know further about this. So, when did ADR actually start in India?
This ADR is not a new concept in India. Indian culture has embedded it from the time of Veda period. It is nothing new. I can say that we cannot say that arbitrator was not there, or mediation was not there, or conciliation was not there. If you look into Vedas, if you look into Raja Maharaja stories, if you look into Chanakya, Chandragupta, and also if you look into nowadays trend also, you find that there were existing arbitrators and mediators. The existence of ADR was not a new concept in Indian culture. For example, if you take Alexander and Porus, there was also a mediator. It is not that they did not have any mediators between Chandragupta and Chanakya and everybody. And so also, even British rule also, because the Britishers has brought arbitration into Indian culture. But arbitration was nothing new. We could not nomenclature it, that's all. See, so during the year 1899 itself, the Indian Arbitration Act has come into existence. So, it's already more than 100 years. It's more than 100 years, and subsequently section 89 of Code of Civil Procedure has come into existence, 1908, which is Civil Procedure Code. And there section 18 has been amended, it has brought into existence, which speaks about the settlement, mediation, other captures. And then afterwards, then Lok Adalats have been started. And then legal aid has started, conciliation has started. So now also there is a latest amendments about 2 years before under Arbitration Act. And then, so it is, what I can say is going to the court and knocking the doors of court all the time for even petty issues is not correct. It is not required even. Because if you can get your ideas or your solutions on your own, it is not necessary to go and approach the courts.
Right.
So that is why section 89 has been amended. See, these are all post-litigation and pre-litigation. What we call these court proceedings. Normally, when you go to the court, after consulting an advocate, after filing case, and after only the court will refer you to the mediation under section 89 of CPC. See, these are all post-litigation. Correct. But what I am interested is in pre-litigation.
Okay.
So, the pre-litigation period is most crucial and effective because of the reason there is only vengeance against each other. You may have some hard burnings against each other. But so far as animosity is concerned, loss of amount is concerned, time is concerned, energy is concerned, you can avoid. It is not that you cannot avoid everything, isn't it? So what happens, because if at all is there any dispute, then it can be resolved either of the five, that is either through arbitration or through mediation or through conciliation or through negotiation or through the patterns.
Oh, yeah.
That is how it has.
So, this is actually existing from time immemorial.
Immemorable, from the date of Veda.
From the date of Veda.
Yes.
But it's so nice that you're bringing into light and making us aware of all these things. So, how does this work in India?
Well, that's what I said, because Indians are not new to this mediation. For example, you know, in each and every house, in each and every education institution, wherever you have studied, either government or private, when there is, say, some problem or some misunderstanding between the student and the teacher, they take the issue to the principal. Who acts as a principal now? Principal acts as a mediator between the child student and also the student and also the teacher. So when she can act as a mediator, and she tries to resolve the dispute, maybe petty, maybe big or something. So mediation is nothing new to the child even. When it is born in the house only, when it has got some difference of opinion between mother and also sisters or brothers, the child will run to the mother first or father to the first, and it will say, Amma, see, my brother has hit me. Then the father will come and mediate. He will say, don't hit him. It's not correct. Teach him the correct ways. So that is where the mediation starts. It is nothing new. But accepting at that age when they were innocent and in the ignorance of law was very good. But after you reach certain age, your egoism will raise. Your financial position status will raise in the society. And it will have a clash on all of you. Because of this, the people who knows even that there exists a mediation center, there exists Lok Adalat, there exist these settlement forums, they don't approach. They only approach courts. That is why I am here to make them understand the elaborate ideas of mediation, arbitration, conciliation. And here, normally when you go to the judge will give you the judgment.
Right.
But in mediation, you are the judge. You are the judge. That means you are mediating. What is that you want? You will analyze yourself internally. Why am I disputing? Why I am asking for something which I cannot even afford? So we make them to analyze what is their dispute, what is their status, what is that they want. At the end, what will make them happy? So it is a win-win situation for both the parties. When a settlement is arrived, both the parties will say, what I wanted, I may get less, but I am happy. So ultimately, that is why it is nothing new, and nobody can say that it does not work. I can watch for it because many times it is not 100% foolproof. 100% we cannot say that 100% we will give you the judgment, we will give you the happiness, we will give you whatever you want, because there are failures. In each and everything there are failures. But if it saves your kith and kins by not fighting, why don't you give a try? When it is less expensive and less time it consumes, it does not consume very too much time.
Correct.
So you can give a try, give a chance. Instead of going today and knocking the doors of advocate and then making file and then complaining and going to the court, waste 2 months like this. Make a minimum benefit out of that. Maximum benefit with minimum cost.
Right.
That is what we say.
But with all this, madam, why do you think that it's not very successful in India?
That is what I said just now. Because why it is not successful? Only because the people does not understand the concept of arbitration, mediation and conciliation. The concept of court is more vulnerable. They are very good with that. See, they are ready to take the judgment rendered by a third party based on the documents, based on the evidence, and then, but they are not ready to accept their own truth.
They only want to believe in judge
That's
and the judgment.
judgment.
Right.
And when they are not happy, they will go in nothing.
They will.
So instead of that, they should analyze what is that they want out of this dispute.
Right.
Even though if a case has been filed, I have seen in mediation center that there are many cases which comes for mediation center are settled. That means they had a mind to settle the issues, but they did not have a mind to approach an arbitrator or a mediator. Why? Lack of knowledge, lack of publicity, lack of legal, what they call that, legal knowledge and other things. So when I say that, no, this is very good, madam will say because she is running the show. It is not, it is incorrect. You please give a trial, see what happens to you. For 2 months, for 6 sessions, normally we take 6 sessions. And then very less cost when compared to the court fees, lawyer fees, and then waiting in the queue, making documents, bulky documents and giving it to the court. Here you don't need any documents. What you want is a person with a positive mind.
Right.
When a person comes with a positive mind that I need solution for my problem, 100% you will get the solution. A person who comes with negative solution, what I get, I don't get anything. Definitely it is very difficult for us also to convince the mind. Human brain is something that they get influenced for negatives very fast, but they don't get influenced for the positive things. So that is why we have come before this forum, and then now I have told you only physical features of water mediation, how it can be given a chance, it can be taken as a chance, an opportunity to save your relationship. In the future series, I will be taking taking many examples. Along with examples, I will call many experts. I will request the experts to come and place before the public how the mediation or the arbitration works in India. How will they get? That is how I care.
Oh, great. We've now seen a lot of advantages spoken by Mrs. Anand about alternative dispute resolution. Further on, you can watch many more series regarding different subject matters of mediation, conciliation, and arbitration. Stay tuned to watch more. Thank you.